how the law works when your relationship doesn't. I am Reed Aronson. I am a partner at Aronson, Majewski and Sloan, a divorce law firm here in Manhattan. And this is my wife, Vanessa.
I'm Vanessa Aronson. I am not a lawyer, but I'm happy to be here.
So thank you for joining us this week. I hope you also joined us last week. If you didn't, you can catch our reruns all on YouTube, on our YouTube channel, Unhitching Hour. So please come do that. If you like this, I'd appreciate it. Last week, we talked about an issue involving children in some, in an untraditional sort of situation, specifically with a lesbian couple. And this time, we're going to be also talking about sort of something that might be considered less traditional, but a little bit different. This time, we're going to be talking about frozen embryos and what happens to them. Obviously, this has been, this is a topic that the IVF has been, or in vitro fertilization has been something that's been around for a long time. But at some level, in a lot of states, the law is not necessarily figured it out yet. So we're going to talk a little bit about how they deal with it in New York and maybe contrast it to some other states. And we'll see, where things stand. And maybe you could use that information for those of you who may be going through something like that to protect yourselves and to know what to do for yourselves.
Will you remind us what's the format here? How are we presenting?
Thank you. So what we're going to do is we're going to see a little video. We're going to see a little video of the facts of this week's case. A little video of the facts of this week's case.
Going multimedia here.
Vanessa is going to ask me some questions, maybe about the facts or some other things, and I'll try and answer them as best I can. And then Vanessa's going to opine on what she thinks ought to happen, right? Based on not necessarily the law, because she's not a lawyer, but her intuition, her sense of morality, her ethics, those sorts of things. And then I'll explain what the court did. And then maybe we'll talk a little bit about the implications of that. We'll talk a little bit about what other courts have done. And we'll see where that takes us.
Great.
All right?
Great. All right. We're going to a video now, you said.
Going to a video.
All right.
Oh. This week's case is called Cass v. Cass. It's from New York in 1998. Maureen and Steve were a married couple who were trying to have a baby, but unfortunately they were having some difficulty conceiving, so they went with in vitro fertilization. The first round of IVF didn't work out, and neither did the second, neither did the third. In fact, 8 rounds of IVF, none of them worked out. But they were determined, so for time number 9, they were going to go with a surrogate. But before they could do that, the IVF clinic required them to sign a form. And on that form, Maureen and Steve indicated that in the event they were unable to make a decision regarding what would happen to the excess frozen embryos, those embryos would either be donated to the IVF clinic for biological research, or they would be disposed of. So they went ahead and they tried, but unfortunately, the 9th attempt of the surrogate didn't work out either. And a few weeks later, Maureen and Steve, they got divorced. But there were still these embryos that were left over. And the question in the divorce was, what happens to the embryos? Maureen wanted them. She wanted to use them to try and have another child. Her argument was, it's my body, my choice, right? If these embryos had been implanted, there'd be no question it was her choice. Also, she argued that it was her last chance to be a biological mom, given her age and other factors. On the other hand, Steve really didn't want them to be used in this way. He wanted them disposed of. He said, look, we signed the form, which said what would happen to these embryos. Also, he argued, look, I shouldn't have to be forced to be a father if I really don't want to, especially with somebody I'm not in a relationship with anymore. And that's where the courts picked up this case. Okay, so those are the facts. We've got these embryos, I think 5 of them.
Oh, there are 5.
There are 5 embryos. There are 5 frozen embryos. I think technically the scientific term would be pre-zygote.
Okay.
Because they've been, I don't know the distinction, but for people who in the audience who might, they're technically pre-zygotes, but they are, ready for implantation. They're frozen and they're sitting in a tank at this IVF clinic, and we've got to figure out what to do with them.
Okay. Interesting. So they are no longer married, but they still have the frozen embryos or pre-zygotes. And he presumably wants to dispose of them.
I think he would be indifferent between them getting disposed of or being used for research, but he does not want them used. Okay. He doesn't want them used to make a child.
Okay. So he doesn't want them used, and she does.
And she does.
Wants them implanted despite the fact that they are no longer married, despite the fact that they're getting divorced. She still wants to use them. Okay. Yeah. So there's a part of me that wants to think this through, like the first way, if they were actual children, mm-hmm. Even though I'm not saying that pre-zygotes are human lives, but okay, so if they had 5 children instead of 5 frozen pre-zygotes, I mean, he would be the father. He can't, unless he like renounced them or something. Can you do that?
I mean, you can, but not. It's not that easy.
Disowned the 5 children and another partner adopted them, right? He would be the father and he would have the rights and responsibilities of a father. So there's like a part of me that feels like when you would go through this process of creating a frozen pre-zygote, that you should have to think that through ahead of time to say like, okay, well, what's going to happen? Like by kind of similar to last week, by like donating the material, you are authorizing the potential for this human life, right?
Yeah.
But that feels like really dangerous to treat them as living children for like a lot of other legal reasons. So then my other sort of thought is, what if they're considered property? Mm-hmm. Right? So, I didn't know how many there were. So there's 5.
There's 5 left.
So in an ideal world, if they were property and there were an even number of them, like the logical thing to do would be like to consider them marital property and to like divide them, right? And that like each spouse gives up their rights and responsibilities of the others. And if he wanted to dispose his 2.5, I don't know how you deal with the half, and she wanted to implant her 2.5, that like he would no longer be the father and she would no longer be the mother of either spouses. But then
that doesn't really solve the problem though, right?
And then I also think like it would sort of like, what if you created some sort of like Parent Trap situation where like 12 years later,
right?
These 2 girls arrive at camp.
His objection is not like I only want her to have 2 children or I only want her to have 3 children, right? Or as opposed to 5. His objection, like I think his objection would be the same if there was 1 or there was 5.
But I'm saying that like they would give up parental rights and responsibilities. That by like dividing the property, like just if you are dividing like, marital property, if you're dividing the artwork in your home, you get this painting, I get this painting, like I no longer own the one you have.
But of course, children aren't property, right? If I give you a car and you drive that car into a tree, I'm upset that the car's gone, but I don't ultimately have to pay to repair it. Right.
Well, but that's what I'm saying. I'm saying that you would give up the rights and responsibilities. So then that also makes me think, okay,
how does that work for the child?
Well, what about last week's example? Mm-hmm. Like there are sperm banks and egg donors, that exists, right? So there is a world in which someone signs away the rights and responsibilities to their genetic material. Could that be a potential solution in this case? Like, I realize it's slightly different. And again, I'm not sure if like the Parent Trap example of splitting them and how you would split a 5th one. I have no idea. Maybe, I don't know. But like, couldn't there be a world in which he could say, or she could say, like, look, these are now your property. And just like as if I donated my egg, or just like if I donated my sperm at a sperm bank, I am signing away those parental rights and responsibilities.
But isn't the key that you'd sign them, that you'd know that was the deal going in?
Well, ideally, but you're saying that there wasn't that. Like, I guess that's what I'm saying is I'm surprised. Well, and that I guess was my question to you. Do you know, and maybe this has changed because of this case, when someone goes through the process of in vitro fertilization, what are actually what are they agreeing to in that process? Because there are excess pre-zygotes that are created often, right? Isn't that part of it?
So I guess what do you think? So in this case, you're the judge. What's your order?
I'm going with my parent trap.
Parent trap scenario.
So
dividing them.
So there's
dividing them in
5.
half, flipping a coin for number 5.
Oh, flipping
a coin for
there
number
you go.
5.
I like it.
Okay.
Yes, and saying that then. And he can do whatever he wants with the embryos or the pre-zygotes that he gets. So he can implant them in, obviously not himself, but in someone else, or he can choose to destroy them. And she can implant them in herself or someone else or whatever, or choose to destroy them or pay to hold them indefinitely, right? Isn't that what you do?
Okay. So,
yes, we got a comment that Gilda is in the background.
Gilda is in the background.
She is playing with her activity, Matt. Yeah, sorry if that's distracting.
That was That's okay.
Why don't you just move? We can move the activity, Matt. She's not going to be happy.
She's not going to be happy. So here's what the court does. And it's interesting. So this goes through 3 layers of courts, right? There's the trial, there's an appeal, and then it goes to the top court in New York, which is called the Court of Appeals. Okay. And it's a different decision in every level.
Really?
So the trial court, which in New York is called the Supreme Court because we have to be confusing for some reason. The trial court says basically, I look at this like Roe versus Wade, right? Mm-hmm. That if these were implanted embryos, we wouldn't have a question. If they had a contract that she would have to have an abortion, that wouldn't be an enforceable contract. So the only question is, it's her choice, it's her body. Wow. So therefore she gets them and she can do whatever she wants with them.
So by creating a pre-zygote, the court ruled that it belongs now to the female.
It belongs, the frozen embryos belong, I guess they are her choice if she wants to use them. Look, I don't know if she had plans other than to use them for herself, if it would be a different story. Like if she wanted to go to some place you could sell them. I mean, you can't do that in New York, but maybe some places you can. I don't know, but what that judge says is they're mine. Okay, so he appeals. Okay. And it goes to a 5-judge panel at what's called the appellate division, so the first level of appeals. And that 5-judge panel has 3 different opinions. Okay? 3 different opinions.
They can do that?
They disagree, right? So there's 2 of them. So all 5 of them disagree with the trial court on the sort of comparing it to abortion rights analysis. Okay. They don't agree with that. 2 of the judges say, look, we think that they should be disposed of, and we think they should be disposed of because the form that they signed basically constitutes an agreement. And what that agreement said was, if we can't decide what to do with the eggs, they're going to get disposed of or used for research. And
I guess I didn't even consider that. And you know what, we didn't go back and should we maybe share the last part of the video just to refresh as you're explaining this?
That's all right.
Okay.
So they say
they're saying they're clearly not in agreement.
They're not.
Therefore, the contract they signed.
Therefore, the thing they signed, that's what binds them. One judge, so they've got 2 judges there. One judge says, well, I don't think that the form that they signed necessarily tells us what happened. I think it's a little bit unclear what they meant. And what I think should happen is that whoever doesn't want them used gets a veto. So it's a 2 keys in the submarine situation. Okay. If there's no agreement, both parties have to agree to use them. Otherwise, they get disposed of. Okay. Okay. That's what one judge thinks. And then 2 judges think also, look, we don't think that this form was clear, but we think that what you have to do is you basically have to have a trial. And the trial judge has to decide what's right and fair.
Didn't that already happen?
But remember, the trial judge didn't really think about it from what's right and fair. The trial judge thought about it from the perspective of she has a right? Like if I sued you if I sued somebody to say you can't get an abortion, a judge is not going to look and say, well, should she be allowed to get an abortion? Should she not be allowed to get an abortion? What's really fair? No, you have a right. it's any other right, and I don't get to determine it based on what other people's rights are. But the two judges who ended up losing, right, because they wouldn't have given it to him, they would have sent it down, say we should balance their interests and really look at it from a perspective of who needs them more, who's got a fairer claim.
Yeah.
Okay, so now it gets appealed again.
Mm-hmm.
And this time it goes to the Court of Appeals, the highest court in New York State. And what the Court of Appeals in New York State says, and that is still the law in New York, is that they had an agreement. In short, we want people to decide these things for themselves, right? We want them to figure these things out, not with judges, not with courts, but between them, because they're going to be the best at deciding what to do. And the best way to ensure that people do that is by enforcing their agreements, right? Because if people sign an agreement, even if it's just a medical form, and and we say, well, we don't really care what you said, we're going to make our own decision, people aren't going to bother to do it. And then it's going to be worse. It's going to be much worse. So that's what the court says. They signed a form. The form says if they can't agree on what happens, they get disposed of.
So the form basically is the two keys in the submarine
Correct.
scenario.
The decision was made when they signed that agreement. And since they never got rid of that agreement until the time that they were getting divorced, right, and they were having this dispute, that's what we're going to go with. And that's still the law in New York.
Really?
Yeah.
No, well, okay, wait a second. So what is still the law in New York? The law is whatever you agreed to when you created if there's zygotes it holds, or is
if there's an agreement, you follow the agreement.
So do you know, does that happen? Is there any legal requirement to sign an agreement in order to do in vitro,
there is no legal requirement, but I do know that as a matter of policy, basically all IVF clinics nowadays require you, the same way they require them, Maureen and Steve, they require you to fill something like that out. And it gives you a list of options, but it requires you to pick. And in fact, now let me ask you a question. Do you think it would be different, instead of saying, look, nobody's going to be able to have a child? What if the agreement said, she gets them no matter what, even if he doesn't want to be a father, too bad. She gets them. Should that be followed?
If the agreement says that?
Mm-hmm.
Yeah. Oh yeah,
okay.
Absolutely.
So there's a 2019 case in New York where that's what they do.
Okay, so
right?
the agreement
there's an agreement that says the wife gets them no matter what. I think it was a girlfriend in this case, but the girlfriend gets them no matter what kind of dispute they have. If they can't agree, she gets to make the choice, even if she wants to use them to get herself pregnant.
What if she wants to sell them?
That's a good question. And
can you?
I don't know what the answer to that question is, right? Like, if you have this pre-existing agreement, it seems on one thing, okay, well, they agreed that she could use them to get pregnant, and there's some logic to that, right? Like, that was the first thing.
Finish your thought.
Sorry, that was the first thing that they agreed to, right? That she would get. That was the plan. That was the whole plan. So it makes some sense that just because the circumstances change, that the plan shouldn't necessarily change, right? Now that they hate each other, the plan is still the plan. But what if she decides, I don't want them, I'm going to give them to my sister, or I'm going to give them to, like I said, I'm going to take them and I'm going to go to some state or some country where you're allowed to sell these things, and I'm going to sell them. And now this guy is going to have children running around that he never, with somebody he doesn't even know necessarily.
It seems to me like that you could just fix by the contract saying that she can do whatever she wants with them in her own body or not. But it looks like we have a few questions here. So the first one is, what makes this form binding? Whereas in the case we discussed last week, the agreement the parties had entered into wasn't binding. Good question.
That is a fantastic question. That's from Shelley Gaze. That is a fantastic question. And the only answer that I can think of is that in one case you had a child, and in another case you didn't. I don't really know. And look, in the situation last week, and for those who hadn't seen it, the situation last week was there was a sperm donor who was known to the couple. It was two women who were married, and there was a sperm donor who donated his sperm and wanted custody later on. And what the court in that case said was, look, they knew going in that this was not going to be his child. It was going to be the children of the child of the married couple. But here it's a little bit different. They're following the agreement, but they're really saying that it's binding, right? Even if the circumstances change, it doesn't really matter. You've made this agreement. Go.
We've got another comment. It looks like someone says every friend they know that's done IVF has been required to, I'm assuming that means required to sign some sort of contract.
And I think that's a development that's in line with frankly, this legal principle, right? Because obviously these guys, Maureen and Steve, weren't required to sign something like that in advance, even though they were collecting more embryos than they were using for any given session of implantation. But they were, over time, it has obviously become the practice of you've got to sign something, because frankly, if you're an IVF clinic, you don't want to be in the middle. You don't want to be making that decision.
Yeah.
You don't want a situation where it's unclear and you have to wait for a court to rule, and a court might take years to decide it. So
I have another question. And actually I meant to ask this before we found out actually what happened. What happens if one of the spouses dies, or one of the parents dies before the prezygotes are used? So is that, let's say for instance, the agreement is that that they belong to the woman and the woman decides what will happen. What if she were to pass away before making that decision? Now, who do they belong to? Right.
What if they belong to him to dispose of, and he gets remarried to another woman? Whether the spouse is alive or not. I don't have cases that I can cite you to. The flaw in the Cass case, in my view, and it's my personal opinion. The challenge of it. Let's not say I call it a flaw. Let's say the challenge of it is that they were dealing with a situation where there was this agreement that they could rely on, but they don't really talk about how you deal with it if there's no agreement, or if the agreement's unclear. And they leave a little bit of that to later court cases, which you could do a search and don't really come up in New York. I imagine that that's largely because people try and settle these things, right? They don't want to go to court about stuff like this.
Looks like we have another question. If there are 5 prezygotes, and they get distributed to 5 different women. So this is in the case of whichever person in the agreement gets to control what happens to the prezygotes, and then somehow distributes them to 5 different women. Does the sperm donor, does the father need to pay child support to all 5 women?
That's a good question. Well, theoretically, both, right? Wouldn't both of the biological parents be on the same hook there? Probably. The answer is probably not. But I don't. There's not. Again, this is this is Reed sitting on a couch opining. I don't have a case that I can cite you to, and it sort of supports the reasoning of the 2 judges who thought that there should be a veto. Right? That there are all sorts of implications, not just child support, but just the general notion of of being a parent, right? Being a parent is a meaningful thing, even if you don't have a financial obligation, even if you don't have necessarily even parental rights. It's a thing that matters. And I think this might be an interesting time. So one of the things in my business in divorce law, and I'm a partner at Aronson, Majewski and Sloan, Reed Aronson, you're watching the Unhitching Hour, episode 2, is that every state is going to be different, sometimes in little ways and sometimes in big ways. And a couple of years after the Cass case comes out in New York, the New Jersey Supreme Court is looking at a similar issue. Only this time, the agreement really is ambiguous. Okay, so they're not guided by the agreement. But the New Jersey Supreme Court looks at the Cass case, which is the one we were dealing with, and they say, we understand where they were coming from. And if there's an agreement, obviously we should honor the agreement. But we don't think that it's as cut and dried as that. We don't think it's as cut and dried as that. We really think, look, if there's an agreement, great, but you can also change your mind, right? These things might be frozen for a long time. And if you change your mind, you don't both have to agree to change your mind. All one of you has to do is write a written letter to the IVF clinic and say, I don't agree with, remember what that thing I signed back whenever I signed it? Forget about that. I changed my mind.
Wow.
Okay. And if you can't agree, what the New Jersey Supreme Court said in a case called JB versus MB in 2001 is if without anything else, we'll probably give somebody a veto. But if it's likely that this is the only opportunity that the person who wants to have a child will be able to a biological child. There's some sort of a little bit of anti-adoption chauvinism in some of this that you see. I can't say why that is. It's, I think, at some level just reflecting maybe societal biases, but it is what it is. If this is the last chance that you could have for a biological child, then we'll give the eggs, we'll give the embryos to you.
So it's okay. So it's almost, so the existence of the pre-zygotes in this case in New Jersey is sort of like consent. Like you need to consistently, positively, affirmatively give consent. And if at any time you take away your consent to the agreement, then there is no consent, right? So that's
Correct.
kind of an interesting way to think about it, that like by just signing a piece of paper once is not forever consent. So again, it's sort of like you have to
continually say, or at least not say, I don't want it anymore.
Right. But it's something that you can revoke. And then if either of the parents can convince a judge that this is their last chance to have a biological child, they get preference.
Then they should get preference.
Wow.
And that's New Jersey. So you're talking about, two states. You could be, if you're in Manhattan, it's one rule, and if you're in Jersey City, right across the water, it's a different rule. So that's the way that this stuff kind of works. And I guess the lesson, the takeaway is, really know both what the rules are in your state. One thing that some of you recently, I guess it was last year or the year before, Sofia Vergara, the actress, had a very public issue with this, where she had a boyfriend. They had frozen some embryos, and in her view, they weren't together anymore. She didn't want them to be used, but he did, and he filed a lawsuit in Louisiana. And in Louisiana, as you might imagine, their personhood rules are very different than the Northeast. And in Louisiana, frozen or fertilized embryos can be considered people. And he basically brought a lawsuit on behalf of the embryos, basically to say, we want to be implanted because we want it. Fortunately, that didn't work out. The Louisiana judge, fortunately in my view, I'm sure maybe other people have different views, that didn't work out. The Louisiana judge said, look, I have nothing to do with this. None of this happened in Louisiana. It all happened in California. Deal with it there.
Okay. That's what I was just going to say. Why Louisiana? Why was he able to?
Because Louisiana had those rules. And what he did was he created a trust in Louisiana on behalf of the children.
Okay.
And basically then said, well, now we can sue in Louisiana because I have this Louisiana trust that these embryos are beneficiaries of.
Yeah.
So it was a pretext.
So he was taking advantage of what you were just sharing, that different states, no matter how close or far away, can have completely different perspectives and completely different, laws about this issue. Yeah. And so he was trying to take advantage of it. Huh.
So it's a difficult, thorny issue. It's still, some states have statutes, some don't. New York still doesn't. All these years later, still doesn't really have a statute that governs this.
So what do you recommend then if someone is about to go through in vitro fertilization? What is the best thing that they can do to protect their own interests, to protect the interests of the pre-zygotes, if that's what they want to do, and to ensure that they don't get sort of caught in this legal mess? What should they do?
I mean, the one thing is number one, know who it is that you're doing this with, right? Now, look, nobody can look at the future, and some of the embryos can last for a very long time when they're frozen. So I recognize at some level things change, but really know what you're getting into, and really know who you're getting into it with, because the fact of the matter is that you don't want to be in a situation where a year later it's a battle. And second is talk to a lawyer about how your state works, how your state is going to look at these things, plan. You can sign a form at the IVF clinic, but maybe that form is not necessarily as clear or as precise as you might want it to be, and you might be able to get if you spoke to a lawyer. Now, I know, look, that's hard, right?
Yeah.
In a lot of cases, if you're married to somebody and this is a decision make, it's hard. And maybe what you want to do is talk to a lawyer, both of you talk to a lawyer together when your interests are aligned and when you know that this is something you want to go into together. But plan. All you can do is plan. And I know that families who have to go through this obviously are planning, right? Obviously you're planning, because this is not an easy, I'm sure anybody who's gone through it would know that this is not, if you read the case, you can read the process. It's not easy, but this is a thing that you should think about, because the worst time, and I say this about a lot of things, whether it's these kind of agreements or prenuptial agreements or whatever, the worst time to have to figure it out is when you're angry at each other. Is when you don't have necessarily those warm feelings to try and address these things, and to wait until you're fighting over the wedding china to make these much more consequential and difficult decisions.
So it's sort of like, a lot of people have prenuptial agreements, which I imagine you'll go into it in a later episode. It's almost like in this particular life milestone, like, is this something where you could reach out to a matrimonial attorney and say, we want to make a contract about this? Is that something we should be doing with our own child on the way? Like,
well, we can't, with a child, it's different.
It's just different. But do people go back in and change prenuptial agreements on the
absolutely people go in and they change
birth of a child? Yeah,
absolutely.
Okay.
It's certainly happened in cases that I've dealt with. Anyway, I think maybe we should leave it there.
Well, we can see if anybody has any questions. There's a little bit of a delay, so we'll hold and show off how cute Gilda is.
So this is Gilda. This is Gilda. This has been the Unhitching Hour. I am Reed Aronson. Thank you for joining us. Please like the video. If you're watching on YouTube, please subscribe to the channel. I think that's the little bell that you press, or the subscribe button. It's one of them. I'm not that familiar. But thank you.
What should they do? Like, if there's people who have future topics that they want to.
Sorry, thank you. If you have any future topics or questions that you'd like to ask, but don't necessarily want to put them on live, you can email us at unhitchinghour@gmail.com. And we will, hopefully you'll have a good idea for a future episode that we might find interesting. Anyhow, again, I'm Reed Aronson.